Hello everyone, myself Dr. Rajashree Jawale, Assistant Professor, DG College of Commerce, Satara. Dear students, today we are going to discuss about the new topic, and that is the Sale of Good Act 1930. So in this topic, we are going to study the definition of sale, then the goods, then the difference between sale and the agreement to sale, and various provisions related to contract of sale. So in this particular lecture, contract of sale and agreement to sale, these are the two terms which we need to be understood, which we need to understand very carefully. According to section 4 of the Sale of Good Act 1930, a contract whereby the seller transfers or agrees to transfer the property in the goods to the buyer for a price. So here we need to understand that when seller is selling his goods to the another person and that other person is giving money back to the person who is a seller, so that money will be in the form of cash or check or etc. So here always that should be in a money only, or that may be in a check also. So here it may be absolute or conditional. So in contract of sale and sale, property in goods transfer from the seller to the buyer. This is contract of sale. And in case of agreement to sale, where property in goods transfer is to take place in future time or subject to conditions to be fulfilled, this is called an agreement to sale. An agreement to sale becomes sale when the time lapse or conditions are fulfilled. So here we need to understand examples also. A sells 50 bags of cement to B for a sum of rupees 7,500. It is a sale since the ownership of 50 bags of cement has been transferred to B. So here we can see that actual sale is completed. Now we'll see the example of agreement to sale. Suppose A agrees to sell his scooter to B on 1st February for rupees 10,000 rupees after 1 month. That is on 1st January. This is an agreement to sale. Here A agrees to transfer ownership or property in the scooter in the future. So this is the agreement to sale. Now we'll see the very important aspect, that is there are many concepts in Sale of Good Act like seller, buyer, goods and price. So here if we are talking about seller, seller means what? Who sells the goods. That good may be movable property. One good or the goods moves from one place to another, and buyer who purchase or who buy the goods from the seller will be treated as buyer. So goods may be always movable property, and here price, that may be in the form of cash or in the other form also, which is accepted in the contract of sale. So now we'll talk about the very important aspect, and that is essentials of contract of sale. So here I would like to tell you that contract of sale, in this particular contract, the terms and the conditions and the essentials are same only as the essentials applicable in a general contract. So here the sale of good, this part was previously attached to the Indian Contract Act 1872. But at that time it was felt that these provisions should be made different from the actual act, and that's why the Sale of Goods Act 1930 separated from the Contract Act 1872. So here we need to understand that the act, the Sale of Good Act 1930, which is very important, and the essentials which are there in actual contract is also applicable in case of contract of sale. For example, suppose if I am talking about general contract, so over there should be a free consent, then capacity of the party, legal object, legal consideration, the agreement which should not be void or which should be enforceable by law. The agreement which is enforceable by law will be only treated as a contract. And here we also need to understand that all these essential ingredients will be also applicable in case of contract of sale. So these are the goods which we purchase from malls or the shops or markets. So here if we are talking about essentials of a contract of sale, we need to understand these elements. So there should be two parties. So to constitute a contract of sale, there must be two parties, the seller and the buyer. They must be different person. Since a man cannot purchase his own goods, they must be competent to contract. So competence, that means capacity to enter into a contract, that should be there. Then second is contract. They should be a contract. An agreement enforceable by law is a contract. Since the sale is basically a contract, it must fulfill all the essentials of valid contract. So what is this? There must be free consent, then there should be lawful consideration and lawful object, and the other elements like the parties should be capable to enter into a contract, the object should be legal, and etc. So all these elements will be present in contract of sale also. Now third aspect, and that is transfer of property. So in this contract of sale, there should be a transfer or agreement to transfer the absolute or general property in the goods sold or agreed to be sold. So here the passing of title or ownership is an essential ingredient of contract of sale. So the next is what? Goods. Goods in Marathi we call it as mal. So the subject matter in a contract of sale must be the goods, the property in which is transferred from the seller to the buyer. Goods of any kind except immovable goods may be transferred. That means here in case of contract of sale of goods, there must be a movable goods only. That means those goods which moves from one place to another, or that we can move from anywhere. Only those goods will be the subject matter of this particular contract. The seller must be the owner of the goods, the property in which is to be transferred to the buyer. Now we'll see the next ingredient, and that is price. So here in this contract of sale, price paid by the buyer to the seller forms the consideration in the contract of sale. The consideration in Marathi we call it as pratifad. The consideration for the transfer of property must be property paid or promised. If there is no money consideration, it is not a sale. So in contract of sale, see here in this case I would like to tell you that when we say that there is contract of sale, actual selling of good and taking back the money, this should be completed. And finally, the next ingredient or essential of a sale of or contract of sale, no formalities. No particular form is necessary to constitute a contract of sale. It is like any other contract made by the offer by one party and its acceptance by the other party. It may be in writing or orally made or implied from the conduct of the parties. That means in simple language I would like to tell you, ज्या वेळेला आपण बाजारामध्ये जातो किंवा मॉलमध्ये जातो किंवा मार्केटमध्ये जातो, त्यावेळेला आपण दुकानदाराकडे एखादी वस्तू मागतो, आणि ज्या वेळेला आपण मागतो त्यावेळेला इट इज ट्रीटेड ॲज ॲन ऑफर. अँड इफ द सेलर हू ॲग्रीज टू सेल, सो तिथे काय असतं तर तिथे ॲक्सेप्टन्स असतो सेलरचं. सो या ठिकाणी हा कुठली फॉर्मॅलिटी न पाळता ज्या वेळेला बायर सेलरकडे गुड्स मागतो आणि ज्या वेळेला सेलर हा बायरला गुड्स देतो किंवा माल देतो किंवा जी वस्तू हवी आहे ती वस्तू त्याला देतो आणि त्याच्या बदल्यात तो त्याच्याकडून ठराविक जी प्रिसाइसली अमाऊंट आहे ती किंवा पैसे त्याच्याकडनं तो पुन्हा घेतो, त्यावेळेलाच कॉन्ट्रॅक्ट ऑफ सेल कंप्लीट होतो. दिस इज व्हेरी सिम्पल फॉर्म ऑफ कॉन्ट्रॅक्ट. In this way, we need to understand that there should be two parties, there should be a contract, then transfer of property and goods, and the price, and finally no formality. So in this way, this contract of sale will be complete. So now we will understand the next part, that is sale and agreement to sale, which we have discussed already. So sale, when the actual condition is fulfilled, then that will become a contract of sale. And in agreement to sale, in future the contract will complete. So agreement to sale we have seen already. So here if we are talking about agreement to sale, so here an agreement to sale becomes a sale when the time lapses or conditions are fulfilled. So this is the condition under the contract of sale. When agreement to sale, when it complete or fulfill, then it becomes a actual sale. So these are the points of difference between contract of sale and agreement to sale. So nature of contract. So in sale, this is current selling contract, that means actual selling. So it is executed. Yes, त्याची अंमलबजावणी झालेली आहे. In agreement to sale, this is the agreement to sell the goods in future, that means executory, that will happen in future, that will complete in future. Second point, transfer of ownership. So this is very important thing. When we talk about contract of sale, so ownership of the goods should be transferred from one person to another person. And in case of agreement to sale, ownership of the goods will be transferred in future. Third is transfer of risk. In case of contract of sale, when goods are sold, the risk of the goods shifts with ownership to buyer. जो व्यक्ती माल विकत घेतो त्या व्यक्तीकडे ही जशी ओनरशिप जाते, त्याच प्रकारे एखादी रिस्क असेल ती देखील त्याच्याकडे त्या मालासंबंधित जाऊ शकते. नेक्स्ट इज agreement to sale. Ownership lies with the seller. Risk remains on the seller, not to the buyer. कारण का ॲग्रीमेंट टू सेलमध्ये अजूनपर्यंत काय झालेली नाही आहे, तर ओनरशिप ही ट्रान्सफर झालेली नाही आहे. ज्यावेळेला ओनरशिप ही ट्रान्सफर होते बायरकडे, त्यावेळेला त्याच्याकडे रिस्क येते. फॉर एक्झाम्पल, समजा एखाद्या व्यक्तीने भाजी विकलेली आहे आणि मग 2 दिवसामध्ये ती भाजी यूज करणं योग्य आहे, परंतु मध्ये जर ती भाजी खराब झाली, दॅट इज पेरिशेबल गुड्स. ओके, सो इन दिस केस देर मे बी रिस्क, दॅट पार्टी और दॅट पर्सन और बायर मे हॅव लॉस. सो हे सगळं कॉन्सिक्वेन्सेस त्यांना माहिती असणं गरजेचं आहे. सो ट्रान्सफर ऑफ रिस्क. नाउ विल टॉक अबाउट राईट अगेन्स्ट इच अदर. द सेलर मे फाईल अ सूट अगेन्स्ट द बायर फॉर प्राईस. आणि मग इथे ज्या वेळेला सेलर एखादी वस्तू बायरला विकत देतो आणि बायरची ड्युटी आहे की त्यानं ते पैसे किंवा द मनी शुड बी गिवन टू सेलर. सो इफ बायर इज नॉट पेइंग appropriate money or amount to seller, in that case, suppose buyer has taken property and not given money, then in that case the seller is having right. Seller can go to the court and file a case against buyer, and he can ask to the court for proper remedy. He may ask for the injunction or declaration or specific performance. These are the remedies which are available under the law. And in case of agreement to sale, the buyer may file a suit against the seller for indemnity. Yes, so here even in some cases in agreement to sale, the buyer may file a suit against the seller for indemnity. So this is very important. Right of seller to resale. So in contract of sale, after payment, the goods in possession of the seller cannot be sold. So here, when payment is given, goods in possession of the seller cannot be sold. ज्या वेळेला बायरनी सेलरला पैसे दिलेले असतील त्या पर्टिक्युलर गुड्सच्या संबंधात त्यावेळेला सेलर ती वस्तू विकू शकत नाही. सेलर कॅनॉट सेल रिसेल दॅट पर्टिक्युलर प्रॉपर्टी फॉर विच द बायर हॅज गिवन द मनी. In case of agreement to sell, the seller can sell the same goods again to another buyer. If the here we need to understand that seller can sell the same goods again to another buyer. Suppose a particular buyer previously which he had accepted to purchase, but after some time if he failed, then in that case seller is having right. Seller can sell that particular property or the goods to another person or buyer. So these are the points of difference between contract of sale and agreement to sale. So subject matter of contract of sale. So according to section 2 subclause 7, what is these goods? Goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or forming a part of the land which are agreed to be served or severed from sale or under the contract of sale. Classification of goods. So here there are these kind of classification or category of goods. So existing goods, under existing goods, specific goods, ascertained goods, unascertained goods. Second, future goods. Third is contingent goods. So these are the types of goods. So what is this existing goods? Goods that are physically in existence at the time of entering of contract of sale. What is this future goods? The goods that are to be manufactured, produced or acquired by the seller after making contract of sale. For example, A order B to manufacture 50 chairs. What is contingent goods? Goods whose acquisition by seller depend upon happening or non-happening of an event. For example, A agrees to sell car to B, provided C, who is present owner, sell it to B. Then under this existing goods, specific goods and ascertained goods. What is the specific goods? Goods identified and agreed upon at time of making contract of sale. For example, A agrees to sell his Rolex watch as pointed or specified to B. Ascertained goods, goods identified subsequent to contract of sale. For example, A agrees to sell 40 sacks of rice to B out of 100 sacks. And the other third category is unascertained goods. That means the goods which are not ascertained. Now we'll talk about a formation of the contract. This contract is nothing but a contract of sale. So here we need to understand the formation of a contract. In this section 4, sale and agreement to sale, formalities of the contract. Section 5, which talks about contract of sale and how it is made. So earlier in previous lecture also, or in previous slides, we have seen these essentials of a contract. We have also seen contract of sale and agreement to sale. So now we'll see the very important aspect, and that is rights of an unpaid seller. Yes, so here unpaid seller, he has rights against goods and against the buyer personally, and there are sub rights also. So against good, where the property in goods has passed to the buyer, he is having right. So right of lien, that right is with the seller, unpaid seller. Then rights of stoppage and transit, then rights of resale. So these are the rights of unpaid seller against the goods. where the property in goods has not passed to the buyer. So in this case, he is having right of withholding delivery, then he is having right to lien and stoppage in transit and resale. What is against the buyers personally? Rights of an unpaid seller against the buyer personally. So he can file a suit for price, he can file a suit for damages, and he can file a suit, that means a case, for interest. So these are the rights of an unpaid seller. Yes, so when we talk about all these essential part of a contract, we need to understand the importance of this contract of sale and agreement to sale, rights of seller, rights of buyer, duties of buyer and the seller, duties of buyer and the seller. So today we will stop here, and we will continue in the next lecture. Thank you.